Today, I have with me Managing Attorney of Older Adult Programs, Lizzie Johnson. Lizzie, welcome.
How are you?
Great, thanks. So today I was hoping that we could have an unscripted conversation about power of attorneys. I think it's important that we share some information with the residents of Central Florida. Can you tell me what a power of attorney is?
A power of attorney is a legal document that's in writing where you have authorized someone to act on your behalf. You have legal liability for the actions that they take on your behalf within the scope of that document.
Okay, so can you give me an example of why I might need a power of attorney or why I might choose to have a power of attorney?
A power of attorney can be an extremely useful thing, and it can also be a very exploitive or dangerous document. A power of attorney, like I said, gives someone authorization to act on your behalf, basically with no further permission from you. Once you execute that document, it becomes legally effective on the date of signing. So, as of October 1, 2011, the Power of Attorney Act changed. Some people may have one of those old power of attorneys. If you have it, it's still good. But under the old law, many people, power of attorneys had a springing clause. That means that the power of attorney became effective upon the date that a specific event happened, such as the person became incapacitated. That means that they were ill, they may have had a stroke, they may have been comatose. So when that event occurred, then the power of attorney rights and duties therein became effective. But as of October 1, 2011, if you have a new power of attorney that was signed on that date or later, then that's not the case. The moment you sign it, it becomes effective. And in the power of attorney, you can say what duties and rights you're giving to someone. There's multiple types of power of attorneys. There's a limited. A limited power of attorney is basically a written document where you authorize your agent, the person who's acting on your behalf, sometimes called an attorney in fact, you're authorizing them to do a specific action for you. Once that action occurs, then that power of attorney is terminated. Or sometimes we call it either an action, or sometimes you may have a clause in there that says it ends in 1 year. For example, I authorize my brother to sign my real estate contract on my behalf because I was out of state. That is an authorized activity that he can do. So with that limited power of attorney, because expressly says he has the authorization to execute my real estate sales contract for me, then he can do so.
Okay. So you can make that scope of what they're allowed to sign as large as you would like, or as
Exactly.
okay, so I could be like, I only want you to have this right here.
You can limit it or you can broaden it. And the reason, let me back up. One of the reasons why I talk about limited power of attorneys, which is very good, they're used for a specific purpose.
Okay.
You can also limit your liability, such as my brother is authorized to do the real estate contract, but nowhere in the document does it say he's authorized to go out and sell my car, or he's authorized to go out and change my address with the post office, or he's authorized to do a tax return. Sometimes people have a power of attorney. Let's say some veterans come to me and they have a power of attorney from the VA. Well, that power of attorney authorizes someone to handle their medical affairs at the VA hospital. That's specific. It doesn't authorize that person to go and open a checking account. It doesn't authorize them to close a checking account or write checks on their behalf.
Okay.
Okay.
But
another,
if a service member happened to be deployed, could they could broaden that scope then?
They certainly can. They have something called a military power of attorney, which we will not go into today, but military powers of attorneys are generally done for service members, and my understanding and my limited knowledge is that generally is done through the military because they have an office there to help the service members execute those, especially before deployment.
Okay, great. That's good to know. Thank you.
Yes. Another power of attorney that people may have is just a general one. It must just say, I give this power of attorney, I authorize this person to sell my house or handle my real estate, including leases, mortgages. I authorize them to change my address with the post office. I authorize them to handle my tax return, whatever. So you can authorize them in general, and that's all it simply says. What makes it durable under Florida law and the Power Attorney Act in Florida is found in Florida Statutes Chapter 709. That's the Florida Power of Attorney Act. And the act specifically says that unless the language or substantial language similar to it says something to the effect of, this is a durable power of attorney, this document is to survive my incapacity, generally then it's not going to be a durable power of attorney, even if it has the language that says durable power of attorney. I have been presented with a durable power of attorney that was 1 page, 1.5 pages. The half page was a signature page, and the first page said durable power of attorney, and all it says, this is a power of attorney. Just because you put durable power of attorney on the document does not make it durable. It has to have the statutory language that's in the statute. That's what's make it durable. Also, it should have duties. The person didn't put no duties. It just said this is a durable power of attorney. I don't think it was effective at all. On top of that, was missing a signature, which we'll talk about later.
So if I wanted to have somebody be a power of attorney, is there a specific qualification? Is it somebody I know, or is there some other way that I find that information out?
On the Florida statute .2102, the language requires in the power of attorney that the durable power of attorney is not terminated by subsequent incapacity of the principal except as provided in Chapter 709 Florida statutes, or similar words to that.
So if I had a senior parent who needed me to help them with something, they could choose me to be their power of attorney.
Yes. You can pick anyone to be your power of attorney. Your power of attorney can be anyone who's an adult. They must be over the age of 18.
Okay.
Hopefully they have capacity. That means that no, you cannot give the power of attorney to someone who has been adjudicated incapacitated.
Okay.
Okay.
That makes sense.
Yes. And so you need to be very careful when you select your power of attorney, because remember, this is a very powerful document. You may trust this person today, but do you really trust them tomorrow? That should always be in your thoughts. Okay. So any adult can be an agent in Florida.
Okay.
Okay.
And am I able to terminate that? Yes. That power, that ability?
Power of attorney terminates at death.
Okay.
It terminates when the event or the date that's contained in the power of attorney occurs. So that means if you limit it by date or by activity, and activity occurs, then it expires. Expires when a court terminates or suspends the power of attorney. It also ends upon death. When you die, the person cannot go and present the death certificate and continue to handle your affairs. You are deceased. Therefore, you don't have any affairs. Anything that you own or anything that belongs to you really is of the estate of you, not of the person of you. Also, you can revoke it at any time. You can revoke it by going through the revocation process, which we will talk later on.
Okay, great. Thank you. Can I still act on my own if I've given somebody a power of attorney?
Yes. This is your affairs. You just authorizing someone to handle your affairs on your behalf. Okay. Sadly, when you give the person a power of attorney, they don't need any more permission from you. Therefore, they can be out there writing checks on your behalf. They can be selling your house without your knowledge. They can be selling your car because you authorized them to do so. They don't have to ask you for permission to do those things because you've already given it to them, because that's the purpose of the power of attorney. Hopefully, you're giving it to someone who you trust and who will communicate with you. Hopefully that's what you would have done. If you didn't, sometimes people become victims of their own circumstance. And unfortunately, in Florida, exploitation of seniors and vulnerable adults. That means you can be a disabled person, someone with a capacity issue. That does occur. And people sometimes use the power of attorney for fraudulent purposes, which is extremely sad and unfortunate, but it is a daily occurrence that happens throughout our state.
That is sad, and I can see how that could become a major issue. So I imagine that trust is of the utmost importance when you're giving power of attorney rights to somebody.
That's correct.
Do I have any protections if a power of attorney commits fraud or goes against my best interest?
Yes. Florida Statute 7092114 has outlined duties that is for agents. There's a statutory expectation that, one, they're going to be acting in good faith and in your best interest. If they use it for a fraudulent purpose, you may have grounds to file a criminal lawsuit against them. And if you're a senior, that means that you are a person who are over the age of 65. There may be heightened statutory penalties. That means additional jail time, additional criminal charges to them because they victimized a senior and violated Florida criminal code. But beyond that, yes, there's besides criminal liability, there may be civil liability, but reality is you may not get your money back. So choose wisely. It is a very hard decision, but can this person handle money? If you have unique assets, is this person able to handle your unique assets? You may have a special art collection that may be worth $100,000, $500,000, and may be very unique. Is the person that you're authorizing to be your agent who's going to be over these assets, are they capable of managing such unique collection? You may not want to include that in your power of attorney. Okay, so you got to be careful about what you do, and I tell clients all the time, you need to limit it in scope, and if you can, limit it in time. Now, you asked me earlier, is a power of attorney a good thing? It can be. It can be a lifesaver. If you at some point lose capacity and your family is unable to afford your health care costs, a power of attorney can be a lifesaver, especially if you have special clauses in it, such as you authorize them to create a special needs trust on your behalf, or if you authorize them to do a personal services contract, or if you authorize them like to sell your home or to purchase insurance on your behalf. Those things are often methods and tools that Medicaid planning attorneys use to reduce your assets and your income to get you qualified for the Medicaid waiver program. The Internal Revenue Code authorizes certain tools or methods to reduce your income and your assets to get you eligible for Medicare. Okay, and so therefore, in order for your loved one to do it, they typically have to have legal authority, and those are now treated as superpowers in Florida. And superpowers are basically enumerated powers that you gave them power or authorization to act on your behalf. But because those were often abused in the past, the law now requires you to initial each enumerated power when you execute a power of attorney. And typically there's 10, such as the personal services contract, the ability to create or modify or terminate a beneficiary account, the ability to create, modify, or terminate a trust, such as a Medicaid trust or a special needs trust, the ability to terminate, modify, or create a charitable donation. These are all all tools that a lot of attorneys who do Medicaid planning or VA planning do to help that senior or that disabled person reduce their excess assets or income so they can pass the asset test and the income test for eligibility purposes for VA or for Medicaid, which is a lifesaver.
Right.
Again, but it has to be somebody you trust versus somebody who's just doing this and going out and taking advantage of you, which does happen and is extremely unfortunate and is very, very sad when it happens.
So I can see where it would be very important to have those serious conversations with somebody before you even sign a document.
Before you come to me, I encourage my clients to have a conversation with their family or their designated loved ones. I encourage them to consider who you want to be your heir, consider who you want to be your surrogate or your if you're doing the power of attorney, who do you want to be your agent? Think about that, because when you come to me, we're going to have a conversation. I don't just pass you off. I like to talk to you about your circumstances so we can have a holistic plan, because I don't believe in estate planning. I believe in advanced care planning, which covers you during life. Estate planning to me really covers your after death. So I like to take care of your life and your afterlife. And that's why I like to have a conversation with you and present to you what your options are and discuss the consequences. But at the end of the day, it's up to you what you choose to do. We're just here to provide you the information and the tools so that you can sleep with more peace at night.
Sounds wonderful.
Yes. Now, again, part of it is talking to your agent ahead of time. Is that I encourage you to do so before execution. If you come to me often, I won't execute your documents unless you tell me, yes, you talk to the potential person. Because in my 16 years of doing estate planning and advanced care planning, it is common for the person to come back to me a month or two later after they talk to the person and say, oh, my agent don't want to be my agent. And that's why I require them talk to your agent and make sure they want to be your agent before we execute your documents. Okay? Because sometimes the parent does, it could be a parent, it could be a child. I've seen siblings, I've seen them all. Their best friend, they're even their loved one, their partner for life, for a long term, say no. The person may not be emotionally competent, or that's not the word, emotionally equipped to handle that duty, or the person may not be in the mental space to handle that particular duty. They have also, sometimes a person comes back and say, I do not want that level of responsibility.
I can see where it would be a lot.
People don't want that level of responsibility. They don't want that level of responsibility. And also remember, when you're passing this off to your loved one to handle your affairs, they're also receiving your family affairs. And based on certain family dynamics, sometimes I do, just by my brief conversation with my clients, I sometimes understand why that particular agent chooses not to be the agent. They do not want to deal with the family dynamics, even though they have a legal document saying that they are authorized to do certain things. They choose not to be involved with additional family pressure.
That is great information. Thank you so much. So, Lizzie, can I revoke a power of attorney?
Yes, you may revoke a power of attorney at any time. Under Florida statute chapter 709, there's a revocation process. You would need to do it in writing. You would fill out a notice of revocation, and that needs to be notarized by two people in the presence of a notary. Revoke the power of attorney in writing. The notice of revocation needs to be given to your agent. You have to give them the notice. That means they need to know, hey, you can't act on my behalf anymore. That also puts them on notice that they no longer have that authority and they can no longer act on your behalf. If they get that notice and continue to act on your behalf, I believe that is blatant criminal fraud. Also, you need to give the notice to anyone that you believe received it. Your bank, if they gave your doctor, present it to your doctor, or if you think they did, you should make sure your medical provider has a copy in the file. If they present it to your local hospital, make sure the hospital knows that they're no longer your agent. Also, very important, you need to record the notice of revocation. It needs to be recorded anywhere where you have real property or where you have personal property, such as a vehicle. That will prevent the person from selling, hopefully from selling your house. When you record the notice of revocation, it puts the world on notice. This person is no longer your agent. Therefore, they don't have authorization to sell your house or your car. So you take the notice, which is 1 or 2 pages, and you take it to your local custodian of records, official records custodian. In most counties, the official records custodian is the clerk of court. Some counties, such as the Orange County Comptroller, they're the official records custodian for Orange County. So wherever you're located at, the official records custodian will take that notice of revocation and record it. So they're going to charge you a nominal recording fee, and it's about $10 for the first page. I believe the second page is $1. But typically the notice of revocation is only 1 page. If you ever need a notice of revocation, regardless of how old you are, call up our office, let them know that, hey, I saw Lizzie on your YouTube page. I need a notice of revocation. Okay. Do an intake, and we will assist you with the notice of revocation, because that's something that's very, very important to prevent exploitation and fraud, and from you losing your home or your vehicle to get to and work and to the medical your medical appointments. That's a very powerful document, and you don't want to delay in revoking it. Soon as you get the notice done, it needs to be recorded, hopefully the same day, with the clerk of court. I try to treat those as, I consider those emergencies, because those are things where you're racing against somebody else's potential bad actions or criminal activity, and you need to do that quickly.
Okay. And I can see where making sure you also hand deliver those notices to the important, like the banks, because I know recording may not show up for a while. So I can see where that would be very important to make sure you do both.
When it comes to sending notice, I recommend, if you can, hand deliver. Some circumstances, hand delivery can not be good. Like, say if you're hand delivering it to the agent, due to domestic violence or potential violence, that can create an issue. Delivering it to the banks during the pandemic, banks are not open. So how are you going to hand deliver it? So I recommend, when you can, hand deliver. Fax, I'm sorry, I'm old school. Fax is still okay, an acceptable mode of communication between you and the lender. Most people still have faxes. Most companies still has fax machines, and it is a acceptable method of communication with an agency or entity, and you can still fax. The third method is you can always still use the mail. I personally recommend, if you can, fax it, because the faxing avoids the human interaction and potential conflict, if so will. Also, you get a fax confirmation. You also should mail it, because the person you hand it to or the person you fax it to may not be the right department. Yes, there's an argument where you can say, well, they was on constructive notice. Well, you want to get into that. You want to make sure it gets to the right person. So therefore, faxing and mailing, if you feel totally okay, then hand delivering and still mailing it to the authorized company. Because sometimes you may be going to your local branch, but the company department is really located out of state, and you just want to make sure they have it.
Okay. That's good information. Lizzie, this has been fantastic. I can see where, if this is something that I'm interested in, or I would have a ton more questions. Is there some place that somebody can look or can call to receive some more information?
Yes. This session is just general information, but if you want specific advice relating to your situation, call up our legal advice helpline. We will do an eligibility intake to make sure you qualify for our services, and then a lawyer is on standby and they can provide you legal advice. If you are a senior, if you are an older adult and you want to sit down and speak to me after the pandemic, and you want an in-person consultation, you can always meet me at one of our community outreach clinics all throughout Central Florida, 12 counties, or you can contact my office and schedule an appointment. There may be a delay since I'm rarely ever at my desk, but I'm always available to help you, or you can call that legal advice helpline and someone can take care of you very quickly. The number is 1-800-405-1417. 1-800-405-1417. We're ready and we're always here to help you. And if we can't help you, we certainly have brochures, we have forms, and these forms are relatively simple where you can do it on your own. I prepared the form packets for you. You have all the information you need to do this on your own if we are unable to assist you, because there's over 2 million people who qualify for our services in 12 counties, and unfortunately we have very limited amount of attorneys. We cannot serve everyone who certainly deserve representation and deserve assistance, but we do have forms and information available to help you with this situation, which is something you can certainly do on your own with our guidance.
That's great. Lizzie, I want to thank you for your time today, and I'm looking forward to our next conversation.
Thank you.
Thank you.
Have a wonderful week.
You do the same.